concerning the proper interpretation of an umbrella clause is actually the subset of a wider question. How do you interpret a bilateral investment treaty? And again, speaking with the usual caveat that these are just my personal views, I think although BIT arbitrations are very much the flavor of the season in India today, I think in many ways it wouldn't be unfair to say that claims under both umbrella clauses and BITs are very much a discovery and not an invention. And the reason I say that is because people just stumbled on the fact that you could actually make a claim under a BIT. You could actually make a claim under an umbrella clause. The first BIT was entered into by Germany in the year 1950. ICSID as an institution was created in 1965. Till 1990, do you know how many claims were brought under BITs to ICSID? Not more than a couple. People just didn't think, and states didn't think when they entered into BITs that these were commitments they were taking on. And therefore, it's one way to look at when Vivekananda said that after the aftermath of the White Industries decision, India decided to reconsider its approach to signing BITs. There are two ways to look at it. One way as a purely knee-jerk reaction, where we don't want international tribunals sitting in judgment over what we do. The other way is it raises very fundamental issues of state consent. And ultimately, the jurisdiction of an international tribunal is no different from the jurisdiction of a normal commercial arbitration tribunal. The jurisdiction of the tribunal is based on the consent of the parties. For a commercial agreement, it's based on consent of the private contracting parties. In the context of a treaty, it's based on the consent of the states. And therefore, states, in many ways, do not think that this is what they had consented to when they signed the BIT. And that really is borne out by what actually happened by virtue of the fact that BIT investment arbitration was almost unheard of till the 1990s, despite the fact that scores of these treaties existed. ICSID as an institution existed for a long, long period of time. Now, there are a couple of points that I'd like to make about the umbrella clauses before raising some wider issues about BITs themselves. The first is, please don't assume that because there is certain language used in a BIT that automatically translates into a commitment that is enforceable by international arbitration. And the states have, of course, entered into treaties which contain language which is now termed as an umbrella clause. And therefore, when I say that in many cases, the claims that are brought under umbrella clauses are a matter of discovery rather than invention, I think it's very much a case of people saying, hey, there's some language here that says that a state has undertaken to comply with any obligations that it has assumed, and we need to make some sense of it. Now, what does this mean? If it means an obligation under a treaty, well, there are these standards under a treaty, FET, expropriation, etc. It can't be those. It can't be protections under international law. So therefore, the only other source of law would be a contract. And therefore, the only way you would make sense of the umbrella clause is by reading in contractual commitments into the scope of this umbrella clause. So that was more an accident. It was more a discovery rather than what states actually bargained for. And even if it is actually something which imposes an obligation on a state, it does not automatically follow that this obligation is enforceable through international arbitration. A BIT is actually a bilateral investment promotion and protection agreement. So there are two distinct elements to it. The first element is promotion, the second is protection. And every single BIT that India has entered into, there are probably around 75, 80, around 82, out of which around 70 have come into force. Every single one of them has an article which provides that India shall promote and shall encourage foreign investment. The words used are in fairly mandatory terms, it's shall. Now, does this mean that failure by India to do this would give rise to a treaty claim? The answer is not. Otherwise, look at the consequence. I mean, there are many of us who work at law firms here, and if a foreign law firm says, well, we can't be deprived access to the Indian market, we have a right, therefore, under the India-UK BIT or any other treaty to say, well, the government of India has undertaken an obligation to promote and encourage foreign investment. You must let foreign law firms invest into India, etc. And can that be a basis of a BIT claim? The answer is definitely no. So there are certain obligations that cannot be enforced by recourse to arbitration. And my personal view is that the umbrella clause probably falls into that category. A couple of general observations about BIT arbitrations themselves. There's much as states didn't really realize that what they were signing up to when they entered into BITs, and India has entered into quite a few, investors too didn't know that they actually have these rights. And this is actually borne out both by empirical evidence as well as what I would say is my own personal anecdotal evidence. The reason why I say there's no empirical evidence that this is something which investors really sign up to, there's nothing to show that the reason why investors choose to invest in certain places is because that state has a favorable network of BITs that exist. The United Nations Conference on Trade and Development has conducted a number of studies, and their conclusion is there is no direct causal linkage between the flow of foreign investments into a country and the existence of a network of BITs entered into by the country. So investors don't think, well, the reason why I invest into India is because there are a number of BITs entered into by India. The reason why investors come to India is because they believe that this is a place which has a fantastic market, it's a place which offers a decent rate of return, it's a place with a lot of potential, and we can actually do business here. In terms of anecdotal evidence, and this has been my personal experience, there's not, I've advised mostly investors, but also a couple of states in investment treaty arbitrations. And the experience of mine advising investors have been, there's almost never been a case when an investor has come and said, well, this has happened in this particular state, can you tell us whether we have a right under the BIT? It's usually the lawyers who do an ex post facto analysis and say that, well, on these fact situations, you have these options. Option number one, go to litigation before the courts of the home state. Option number two, if your contract provides for arbitration, you have a right of recourse under that contract. Well, in addition to these normal things which you would have been aware of, there is something which is quite exciting, there's something which is quite creative, and that is this animal called investment treaty arbitration. And then what lawyers try and do in the analysis is to find some sort of treaty which has a nexus to the particular dispute, and then try and find jurisdiction on that basis. So it's not a deliberate decision by an investor to invest pursuant to the protections under a BIT. It, in many cases, is a post facto analysis by probably a group of creative lawyers who try to find jurisdiction based on a BIT. And in fact, that's really how it happened, because there was a lawyer at Freshfields called Nigel Rowding, and he, in many cases, in many senses, is probably the father of BIT arbitrations. Now, he did an analysis of a few contracts, and he came up with this BIT arbitration remedy. He tested it in a couple of cases against Latin America. He met with success, and then, with success, success breeds success. So if that's been tried and tested in a couple of Latin American arbitrations, then that was replicated across the world. So that's really how it happened. Now, this is probably Thursday's topic, but a couple of observations on that. Should India rethink its approach to BITs? And the reason why BIT arbitrations are sometimes unpopular, and India by no means would be the only state which has reservations about bilateral investment treaties. The United States was really rethinking its what it had signed up to under NAFTA, because the United States didn't think that NAFTA arbitrations would come back to bite it. Australia is rethinking its approach under BITs. India is doing it. Venezuela has reconsidered its option. There have been a couple of states which have actually withdrawn their consent to the ICSID convention. So Ecuador has one. Now, all this means, and the kind of states, is very much the range of the spectrum. It ranges from capital importing states to capital exporting states. Now, if all these states are unhappy or have reservations about the investment treaty arbitration system, then they might well be a serious problem that needs to be looked into. And why is BIT investment arbitration unpopular? One is probably many states think that what BITs do is they unnecessarily intrude into matters that are within the scope of national sovereignty. And under traditional principles of international law, courts would generally give sovereign states a very wide degree of latitude in taking decisions which are within their national interest. But this is changing in the context of the BIT scenario. Let's take the 2G scam. Now, a number of claims have been threatened against India. Sistema, a Russian company, has threatened BIT arbitration against India. Telenor, a Norwegian company, has said that if its grievances are not satisfactorily addressed, it will consider making an arbitration claim against India under the Singapore-India SICA. That's how it had actually structured its investment in the country. Now, let's look at it one way. Now, what happened in the 2G scam? You had a situation where there was a tainted transaction. And the way the Indian Supreme Court decided to deal with that tainted transaction is to actually completely nullify it. Now, that's by itself not something which is unacceptable. If you have a tainted transaction, it should be set aside. Now, that might ultimately have the consequence of affecting the rights of foreign investors. But it's been a well-settled principle of investment treaty jurisprudence that BITs are not insurance policies against legitimate business risks. So if companies invest into India, knowing fully well that the regulatory environment is uncertain, that there may be issues which may not be completely above board, then that's a legitimate business risk of operating in a business environment which is not yet fully mature, maybe dealing with a situation which is not known to be the most transparent. Now, these are risks that are inherent with every foreign investment. And what the Indian Supreme Court did is by no means unexceptional. Now, states are quite uncomfortable. Now, if this decision is called into question by a BIT tribunal, then that might actually raise real questions about what is the scope of national sovereignty. The second reason why states are fairly uncomfortable with BIT treaty arbitrations is there is an element of doubt about how BIT awards are consistent with general principles of international law. Now, Mr. Rao will tell you that when the International Court of Justice decides cases, there is a strict adherence to the sources of international law. If you need to base a claim based on customary international law, you are obliged to prove that a particular principle has actually crystallized into a principle of customary international law. You'll have to prove that state practice exists. You have to prove that that state practice was accompanied by opinio juris, so that a particular norm that you're relying on has actually crystallized into a principle of customary international law. And with investment treaty arbitration, that thing has changed. You have very easy shortcuts. Let me give you an example. A couple of years back, Bangladesh was held liable. This case called Saipem versus Bangladesh. Now, Bangladesh was held liable for not really enforcing an ICC award. And the principle that was relied upon by that tribunal in that case was the principle of abuse of rights. The tribunal based its decision by saying that failure by Bangladesh to enforce the ICC award was an abuse of rights by Bangladesh. And therefore, that became the basis for the tribunal to find against Bangladesh. Now, isn't that controversial? I mean, is there consensus about the fact that the principle of abuse of rights has actually fructified into a principle of customary international law? If you look at Brownlee's textbook on international law, he very categorically states that the principle of abuse of rights is controversial and it has not yet crystallized into a principle of customary international law. Now, how does the Saipem tribunal conclude that the principle of abuse of rights is a principle of customary international law? I didn't see a single precedent. I didn't see any evidence of state practice. I didn't see any analysis of opinio juris. The law of customary international law, therefore, is what the tribunal said it is, without adherence to sources of customary international law. And that's what makes BIT arbitration unpopular. Let's look at what happened in the White Industries case. And sometimes you can see the lack of rigor in decision making. And in many cases, it really is a question about who you appoint to a tribunal. Without intending to be provocative, let me say that Judge Brower, who is a judge in this case, is probably the most favored arbitrator if you're acting on behalf of an investor in an investment treaty arbitration. And in fact, if you look at his record of appointments, especially over the last 5 years, I would be very, very surprised if a single state has appointed him to a tribunal in investment treaty arbitration. Judge Charles Brower. Now, Judge Brower has always been appointed by the investor. There have been cases where he's been appointed as a chair by the appointing authority. Similarly, there's also someone on the other side of the spectrum. There's Professor Brigitte Stern, who's a professor in Paris, and she has almost always been appointed by the states. There's not been a single case where she's been appointed by an investor. So people have ideologies. And the reason why you appoint particular people to particular tribunals is because they believe their ideological position will suit your interest in that particular arbitration. And this is something which is an inescapable fact of investment treaty arbitration. So if this is how decision making works, and if you apply the logic of American realists, and you can predict a decision by when the tribunal is constituted, what is it that makes investment treaty arbitration more legitimate than national decision making? Now, what gives a three-member tribunal sitting in The Hague the authority or the legitimacy to sit and appeal over what the Indian Supreme Court has done in case of the 2G scam issue? Now, these are serious questions that are raised by investment treaty arbitration. Let's look at what happened in White Industries versus Australia. Here, India was held responsible for breaching a BIT provision because the foreign investors struggled to enforce its award in the Indian courts for around a period of 9 years. Now, anyone who's dealt with Indian litigation would know that delays are a part of the process. Now, when White Industries decided to make an investment, it probably knew of this, and then that goes back to that well-settled principle that BIT arbitrations are not an insurance policy against legitimate business risk. So if a legitimate business risk of doing business in India was that you might have to wait for a few years before you can get a final judgment or a final award, can that be the basis of an award against the state? And see what happened here. And Judge Brower was sitting on this tribunal. He was previously a member of a tribunal in a case called Chevron versus Ecuador. And what really seems to have happened is there were virtual passages that were lifted from the Chevron versus Ecuador award and was inserted into the decision in the White Industries versus India award. And there's no system of precedent in investment treaty arbitration. And what every tribunal needs to do is integrate different treaties. And there is a world of difference between the Chevron US bilateral investment treaty and the India-Australia bilateral investment treaty. But that was glossed over because the Indian bilateral investment treaty says, well, although India is obliged to provide means of redress, effective means of redress to a foreign investor, that right of redress should be made available in accordance with home state law. And that part, how that section, in accordance with its own laws, is not something that is there in the Ecuador BIT. Now, why does this make a difference? The reason why it makes a difference is because an Indian citizen has to wait around 10 to 12 years, or maybe even more, to enforce a foreign award. And therefore, there's no element of discrimination. That's how long it takes. Now, if the import of the decision is that a foreign investor must be given preferential treatment and must be allowed to enforce its award in a period of 6 months or a year, then that probably infringes Article 14, which probably is the cornerstone of the Indian Constitution, because then what you're doing is you're discriminating in favor of a foreign investor against someone who's similarly situated simply on the grounds of nationality, and that would be contrary to the Indian constitutional scheme. So these are the difficult questions that are raised by BITs, and states have an element of disquiet because these are factors, these are nuances that may not be very well appreciated by a number of people. So it's all very well to say, well, we're quite unhappy with what the government has done. What we're going to do is commence a BIT arbitration. Look at what happened in TCI, the case that Apar was just referring to. The Children Investments Fund is a hedge fund. And what was its investment? It hasn't actually made an investment in the sense of establishing a tangible investment in India. And the whole purpose of BIT was to encourage tangible investment by means of having a power plant established in the territory of a host state. It generates local employment. It contributes local tax revenue. Now here was someone who just simply subscribed to the shares of a company and is quite unhappy with the decision making of that company and then threatens BIT arbitration. Now is that what these arbitrations are meant for? What would be the normal means of redress for an investor in a company? The first one would be, you'd see whether there's a basis for making a complaint of oppression and mismanagement, and you'd approach the company law board under section 397 of the Companies Act and seek redress. TCI didn't do that. What is the other alternative? you call for an extraordinary general meeting, and you try to persuade the other shareholders that what's happening, the decision making of the company is something that needs to be relooked at, it needs to be revised. But that didn't happen. What the investor did was straight away threaten investment treaty arbitration. And the question that I'd leave for all of you to ponder about is that something which states had given their consent for when they consented to BITs, or when they actually signed and ratified BITs? These are just questions, but I'm sure these are matters that need to be discussed further. I'm sorry if I've digressed from the topic a bit. Thank you so much.
In fact, it leads the discussion back to some big picture questions about institutional capacities for how states might approach arbitration and what might be the considerations within these arbitration tribunals, whether they are repeat players and whether that distorts the kind of decision making which happens in these fora. So Aditya, you can move to your presentation now, and then we'll have Mr. Rao commenting on everything. Yeah.
To what the panel's been discussing till now. So the question that I'd like to throw out there, and maybe it can be discussed after I talk about attribution bit, is this whole question of literal interpretation and the interpretation that has been adopted in, I'll just take the two major cases of Philippines and then Pakistan, and whether this literal interpretation and this wording of the clause has really been useful. And the reason I say that is the rationale, and I think the wording in Philippines was that shall observe obligations, as opposed to Pakistan, which is shall observe certain, shall guarantee commitments. Now, the Philippines, the tribunal stated that one of the major reasons it would grant a wider interpretation is because of the use of the word shall, which gives the sort of obligatory nature to the clause and gives it a wider interpretation than it would otherwise have. The same wording is there in Pakistan as well, where it says it shall observe. The only other difference would be where Philippines has obligations and Pakistan, I think, uses commitments. Now, shall guarantee commitments versus shall observe obligations, I don't personally think there's a huge amount of difference in the wording of the clause, at least not one that would change from a wide interpretation to a narrow interpretation. So that's one thing that I would like to say. The second thing with respect to the literal interpretation would be, and this is relating to how the scope and the objects and purpose of a bilateral investment treaty, and which is why I sort of support the stand taken in Philippines, is that if the general nature of bilateral investment treaties is seen, like the way they've developed, and an example is that bilateral investment treaties have been sort of given a broader scope, and the easiest way to gauge that would be like maybe the definition of, say, investment, which has changed. The present most popular definition for an investment is the current one used in the 2004 US model BIT, which says an investment is anything which has the characteristics of an investment. So sort of it's circular, but it's the broadest interpretation that can be given to any investment, right? And if that's the object and purpose of a bilateral investment treaty, to sort of encourage investments and have as many investments as possible under the BIT, then I believe that the Philippines position is possibly the more correct one if they're both essentially the same clause. Now I'll just proceed on to my presentation, which is essentially on attribution. But what I'll specifically deal with is whether the ILC articles on state responsibility and the principles outlined in the ILC articles on attribution apply to bilateral investment treaties, and more specifically umbrella clauses. Now I've outlined 3 questions, and all 3 questions I believe at the end tie up together, because they all help answer the general question on attribution. The first question is, what is the extent on which tribunals should rely on the allegations made by the parties? Now, the 2 standards again is the one in Pakistan which says that a prima facie case needs to be established. Now, this was made to a more stricter standard, where in Philippines they said that not only must there be a prima facie case, but also there must be fairly raised questions which the tribunal was examining. The reason this becomes important is that while determining whether, and this is a normal umbrella clause will be framed like, and this is something I'll deal with in my third question as well, is each contracting party shall observe any obligations it has entered into with an investor or an investment of an investor of any contracting party. The problem here is known as the it problem. So what do you mean when you say it? Does it include only the state party, or does it include, say, state-owned entities under the party itself? The reason the standard of evidence becomes relevant is that what should the tribunal look at when the claim is initially brought before the tribunal? Is it supposed to make a more detailed analysis? And this becomes all the more relevant when it becomes a case of attribution, because you can't make that determination on the face of it. You may have to make additional determinations which are relevant. So which is the standard the tribunal should adopt while determining, while looking at this question of attribution? The second thing I've looked at is how attribution is not general in nature, but only in the case of a violation of an international obligation. Now, the difference between the two would be like, as per the ILC articles, attribution is only considered when there has been a violation of an international law norm, or there has been a violation of international obligation. Attribution, the question of attribution does not arise in a general context. And if I can just give this through an example. So there's a difference when there's a conclusion of a contract, and a difference when there's been a breach of a contract. The question then becomes, at the conclusion of the contract, can you attribute the same sort of the entity to be a state entity when the contract was concluded, or do you only look at this question of attribution when there's a breach of the contract? And this becomes relevant because so what is the private investor, what is the frame of mind, what was the intent of the private investor when he's contracting with the state or the state entity? Was he aware of the fact, say it's a state-owned entity, was he aware of the fact that the state-owned entity will be subject to a BIT? Was the contracting party aware that this remedy will be available to the contracting party when there is a violation? Because there's a difference between when the contract's been concluded and when the actual breach takes place. And attribution, as per international law, is only to be looked at when that particular breach takes place. And this is similar to a question which Mr. Pramod Nair said, what was the intent of the parties when they subjected themselves to the arbitral jurisdiction? And if I can compare it to, say, a question in the domestic sphere, say there are two parties who have contracted or who have agreed to an arbitration clause. Now, they may be a subsidiary of that second party, but was there an intent to enter into an arbitration proceeding with that particular party? And that's what needs to be, that's where the ILC articles becomes relevant, because the scope of the ILC articles is only restricted to as to when there's a breach of a particular obligation. It doesn't really talk about a general sort of attribution which takes place. But inherently, when you invoke BIPs or investors invoke the jurisdiction of tribunals, whether they intended to get into an arbitration process with the state itself is a question that needs to be examined. In my personal view, I agree with the view of Mr. Kalapuk that when you're taking a decision, or when you're taking a call, or when the tribunal has to make a decision as to which party is, whether the state entity is subject to the BIT arbitration or not, the best way to possibly determine that would be the nature of the contract. And I think that's, as far as I see, that's possibly the clearest indicator which exists right now. The third thing I'd like to talk about is whether ILC articles can be used to determine states' responsibility under the umbrella clause particularly. And like I said right at the outset, this is known as the IT problem, because what tribunals have to now determine is whether it under any umbrella clause includes a state-owned entity or not. Now, in order to highlight the problem, I'd like to talk about some of the decisions which have sort of considered this problem. The first was this case of Impreglios versus Islamic Republic of Pakistan. There, the tribunal stated that there is a different standard for states and their violation of international law, and another entity for a breach of municipal law contract. This sort of position changed in Noble Ventures and Eurego. In Noble Ventures, they did consider the ILC articles, where they said that you can attribute the Romanian state-owned entities in that case, and it does extend the umbrella clause as well, and it includes breach of contracts as well. Eurego was sort of different in the sense that it was a more clear-cut case where there was a Minister of State Treasury and he had entered into a contract, and that particular contract was attributed to the state. Now the question that becomes relevant here is what is the extent to which this attribution should be given. And because a lot of these tests, which are such as the structural test, the functional test, the control test, can't be determined, say, at the prima facie level or the stage where the claim is introduced to the tribunal. So with respect to this question of attribution, I think there's sort of a mixed answer which will be, which I think applies. One is that the standard of evidence possibly which should apply is a lower threshold, because you need to be able to determine a lot of things to determine whether attribution can actually, whether the state-owned entity can actually be attributed the same level as the state entering into the BIT. The second thing I'd like to submit is that the best way to determine whether the contracting party intended to enter into a contract which possibly could invoke the BIT would be the nature of the contract, and that's something which Ms. Akila also spoke about. So those are my views on attribution.
For a very excellent presentation in a short period of time, which you took each one of them, did not really bore us at all, and on the other hand, made us to think more deeply and enlarged our perception of what is involved. I have certainly got educated, I must say. So I congratulate each one of you. I think there is certain points of advocacy when Siddharth had, Shreya had picked up on the broader theme of interpretation. I think he was trying to, as opposed to our Anirudh's points. So I think that was a kind of a adversarial type of a discussion there. But I think the more balanced perspectives were brought very quickly by both Akila, and I think I'm very impressed by Pramod Nair's analysis. I think he really, let's say, it's not like a piercing to the corporate wheel, as it were. He pierced the wheel and the mystery that surrounds this relationship between the contractual relationship, contracts entered into by specific agencies and the BITs at the other level. I think he did a great job there. If you look at the scheme of things, the one comment that was made by Vishal is that about the BITs reflecting customary standards up to a point. I would be very careful in that situation to accept that, because BITs came against a background and history of developing countries fighting against very same things which got into BITs later. So therefore I wouldn't consider them as reflections of customary law. I would consider them as concessions being given by developing countries, having argued throughout their earlier portion of their independence against the cargo clauses and things like that in the prompt, the Hull formula. They vociferously argued for nearly 25 years in the Transnational Corporations Code of Conduct, particular subcommittee in the United Nations. And of course, the bigger battle took place when the new international economic order context, where George Abisov and others have all grown up in that debate also, while we were growing up in the other debate of law of the sea. And in fact, the ideological positions of some of our colleagues who are now becoming arbitrators and have become regular arbitrators is very well known, given their backgrounds in these kind of historical participations. And therefore, to say that BITs are reflections of customary law is not an entirely correct statement, because that's why Brownlee, which again you have quoted, brought into picture Pramod, is a very valid point. Brownlee was again an advocate and a defender of, given his socialism and communist card holder, whether it's a communist card holder or it's a socialist card holder in the United Kingdom in his student days, and his orientation, he is the first person who ideologically opposed to all the trends and developments in international law and contest them as not valid at any particular point of time as law and have to be argued again and again. But he is also the one lawyer who used international law more thoroughly than any corporate lawyer would be able to use to the benefit of his clients. So he has a very peculiar personality. Ideologically, he is as revolutionary as anybody you can think of, but most revolutions don't argue like advocates would do for their clients, you see. But he's the best advocate when he comes to advocate. But when ideologically he stands, again he's on the other frontier of revolution. That's why his textbook is very interesting, even though he writes very differently from other textbooks, if you see. That's why only 5-6 pages are there in the entire investment business. But he puts holes everywhere. In other words, he puts his eye and says, this is not law, this is controversial, this is not accepted. So he puts just one line to allow the others to really go after others with his authority behind him. And but then when he argues itself, it's not like a simply saying no to no. He has a lot of meritorious research he did, so therefore people do take him seriously. But I mention this all because all this is a very controversial subject, including the now dovetailing, telescoping the contractual obligations directly into BIT and then trying to get hold of the state is certainly not a in thing. It is an evolving thing. Thanks to the exit arbitrations that have taken place more recently, this has become much more fashionable. And I think developing country advocates particularly, of course we are no longer developing country advocates. This is what I was telling some friends here. We have no third world anymore, even though we have an advocate of third world in Chimney. And we have no particular group of any ideologies anymore. And we do accept that there is a give and take in the modern world. And India particularly, even when we were discussing law of the sea issues, where there is a pro-investment and pro-industry, like in the deep sea ventures and that kind of thing, the investments in the deep oceans, we were developing theses on the basis of extreme opposition to the profit-mongering private industry, getting into these ocean technologies, etc., and asking for the moon and high stakes in terms of the risk capital returns. Very interesting thing happened. We were having cabinet secretary sits and clears the briefs, and all the departments of the Government of India, secretary level departments would sit when they clear the brief for the when before we go to the law conference, because there's a very big national territorial issues are involved, and enlarging the territories are involved in the oceans from 3 miles to 12 miles to 200 miles. Huge economic resources are coming into play, and a lot of business interests are already playing through the American and other sources, particularly oil companies from Texas were constantly nudging some delegations to put propositions which would give them open seas and freedom to have access to these resources and play with them like they would like to do everywhere else. Again, situations like that, when we go to this cabinet meeting, cabinet secretary sitting, and all secretaries are arguing, and legal and treaty division works under one secretary, and then but the foreign secretary is different. Normally, the foreign secretary has traditionally not handled the legal division as a secretary had the civil ministry. So he represented himself as foreign secretary. The secretary, next one is M.A. Velodi, actually he worked with ISRO for a long time, and the United Nations also. And he was our secretary. Our joint secretary was Jagota, and he was presenting the various options in the brief. And when arguing for very sovereign-oriented type of briefs, Foreign Secretary takes a different view in front of everybody against his own secretary, who is supporting the secretary, Jagota. And he says, you are constructing the whole policy as if we are a bullock cart type of developing country. We have crossed that age. We are now investing in Africa. We have investments elsewhere. You should consider ourselves not in the league of these developing countries, but developed countries. Even if you are not there, you should put your sights and says vision in that capacity and look for more broader investment-oriented, industry-oriented, and develop not like you are not a receiver, a beggar type of thing. We are now going to be givers type of thing. So you have to argue. So he would come and was trying to hit the entire process from a different angle. So even as old as that, we had this dilemma as to what is India? Is it a developing country? Is it a developed country? For what purpose are we developing and for what purpose are we developing? Simply because it was called emerging economy and we have $400 billion, you become suddenly a rich man's club man. No, we're still 80% is poor. But then that poverty should color our current thinking of as to what is fair and reasonable when it comes to commercial transactions. If there is equity and justice in those contracts, per se, I think that is the issue here. So it's not a question of what kind of country. We are not, even Mexico and Venezuela and others who have, Ecuador and others who have originally went into this exit and then lost quite a few grounds thanks to the arbitrators whom they could get the right arbitrators. This is the trick of the trade, is to get the right arbitrator, you see. And an arbitrator, what does he do when he sits there? He's looking for the next case. Because he's already on that case, so therefore he's not looking for this case. I'm already having this case, so how do I go about it? So make sure I attract a few others, you see. This is an unfortunate promotional game. You know. This is again not a strict old tradition. Judges won't do this. But the modern generation is go-getters, you see. At every level we have go-getters. Therefore, if I deliver an opinion in such a way that my advocates on the floor are happy or some other audience are happy, I get more cases, you see. Therefore, even if it was my own wish, I will develop a logic to promote myself. This is happening, unfortunately, and this is a sorry state of affairs of concern of our colleagues. And that's why Judge Abisa, for example, who's like Bridge Stern, is always appearing for the state and losing almost all the time and getting almost in half of his hair lost because these other younger lawyers have come and taken over. They're taking this whole scheme of investment protection to a level where anything and everything that happens against an investor is immediately a problem for the state. And he was calling me, in fact, about 2 arbitrations in which he wanted to appoint me as a president because you will get some support for himself. Because we were all old generation, that new international economic party generation. But then the other party knew me as well, so he blocked me from coming in there. And Judge was upset. But this is a natural game, so this is behind the scenes and the reality that of course Pramod brought it. So I mentioned that as a very valid perspective that all of us should keep in mind, that the appointment of arbitrator, choosing the applicable law is very important in all these matters. But on the theoretical questions, on the valid academic and otherwise very substantive questions raised in relationship, my answers would be very simple. First of all, bilateral investment treaties are concluded with no contract in mind. Therefore, to think that all contractual obligations are automatically read into it if something goes wrong at any particular level to the dissatisfaction of the foreign investor is a completely wrong presumption. It's a different matter that by virtue of certain clauses would give, like denial of justice, like proper compensation has not been paid, whether it is due, prompt, effective, or that whole formula was replaced by just an equitable compensation type of thing, and if it is really meeting that standard or not. When we say fair and equitable treatment, if you have entered into certain treaty obligations with other countries at a level of a general level of what kind of treatment they would give to foreign investments in our country, that treatment, if it had not been given specifically by one way or other, it would be read into that kind of thing to ensure that everybody, in other words, like equality before law, it's like the rights of individuals being read into in a wider context, and things like that. But it cannot mean, it cannot suppress or surpass the specific intent of the contract and specific intent of the particular transaction. Because the parties have deliberately, as I think Akhil has very rightly pointed out, that treaty is already there. But when we are negotiating on specific aspects and specific gives and takes. And to the extent that we want to cover our parties, we would say them if they are really meaningful to us and they are necessary for us if you want to bring that dollar to this country. And having done that, for you to say that, that anything goes wrong, ultimately the state, not only anything goes wrong and not ultimately, which immediately the state has to come into play type of argument, is something that has to be scotched. But doesn't mean, like Shreya has rightly said, the bid is an umbrella, not only an umbrella clause, it's not an umbrella clause as if it's automatically read into the contract as it were, rather than the contract being read into the Because there are stages. The old stage, simple theory is a treaty concluded, and I think Aditya has raised this point of state attribution, which is a very legitimate point. Only when there is a denial of justice, either in terms of the compensation not paid or in terms of the forum not being very proper and all the due process of law has not been accorded, or equal treatment has not been accorded, certain evidences which are generally should be read into have been ignored and otherwise not allowed to be run into. I mean, some of these things, can develop into denial of justice type of thing, and then you can come up to the needs. But if these are otherwise have to be played at the level of the forum, which is otherwise prescribed and agreed to by the parties, and if this has been sufficiently not given its own play, you cannot jump the one gun to the other simply because it's more convenient and more expeditious for the other party. I think that is reasonable. But then the question of that there are other questions, whether a state, suppose, if a state enterprise is entered into a contract, is it any more, nexus is any more closer to the state itself in terms of contractual violations to go straight to the state rather than to the enterprise? Again, I would think as long as the state enterprise is in law, an independent legal personality and has its own board of governors and its own budget and its own self-sufficiency available, like any any firm would have it, then naturally the first claim would be against that public agency, not against the state, simply because it's called State Trading Corporation. In fact, the State Trading Corporation and the MMTC have created any number of headaches during our time when they mismanaged their own contracts, and Air India planes are being hijacked and are being put on lien, before the courts. Because it's a state corporation, the judge there in America says, catch anything you find, if I'm working as a diplomat and I have money, so take his money also because he's an Indian diplomat. Nobody is no good. That cannot be done like that. And another thing, these days, very recently, our Indian diplomats have maids who are making big claims, some of the one or two claims against our own diplomats and maids, they ran into some $1 million recently. The compensation was $1 million compensation. Where will the diplomat will pay that, I think? State has to pay for it. This is again a very interesting thing. You carry your own servants to the foreign country, and these fellows jump out of the house in a few minutes, very quickly, and then go and complain. This fellow tortured me, this fellow did this, this fellow that, and then they will go and get a big claim. And the fellow has to go, so you will get $1 million, which the diplomat can pay, the government servants, they are not with this one. So the government will have to pay for it. So anyway, there are 2-3 claims have come up like that. And then there were times when bank accounts of the foreign diplomatic bank accounts are being attached for some of these claims in Europe, Brussels, etc. So we all fought those cases and successfully survived in terms of securing the sovereign funding and sovereign status, as opposed to we link it to these things by making necessary arrangements at reasonable arrangements and negotiated arrangements. And the funny thing is, if BITSI ultimately is the only basis on which investment claims have to be settled, why not the other state comes into play? And why is this private party is coming into the play and then the other party is happily sitting somewhere else? And in fact, it's only wondering if somebody else will file similar case against it, and therefore, like, all these countries are ganging up like states now and wondering about how to make sure that these investors don't come after them, even if one of their own investors had done the trick against another country and got a certain benefit out of it. And then the abuse of rights and acquired rights and this prompt for just compensation being exploded into a status of exorbitant claims beyond reasonable expectations and legitimate expectations is certainly a big problem in these cases. Therefore, on the whole, I would argue that once a contract is entered into, the contract must run its full course. To the extent that the country is like in Latin America, this is quite possible. They are not providing the kind of forums which they otherwise would promise under the bids. That's why the exits were going after them in a much bigger way. But I don't think it happens in countries in Southeast Asia or otherwise in India, except our bane of our problem is this delay before the courts. But the delay before our courts is also, of course, some of you as younger people going before the courts should be able to really throw some light on it. I think if I want to get a case somehow surface out of this, in fact, in India, what is the queue everywhere? Everybody is jumping, like a group and then push yourself into it, right into the, whether it is a bus we are waiting for, and otherwise it is a bank line we are waiting for. Even in the court, I'm sure, if I want to get my case on top of the docket against 20 others sitting there, I could get it, I think, if I want to. But I'm only using that as an excuse to make sure that things dilate on their own. I think otherwise, how come these 2G scams cases go straight into the case when so many cases are lying there? Yeah. That's another way of doing it. You can also, if you can telescope so many the arbitration to BIT, you can put them as a fundamental rights also, I suppose. You can also go to the other extreme and get it there. But I have a feeling some of these things are exaggerated, some of these things are downright misused, and therefore we get into bad name and bad game. But I think on the basis of it, bids are at a different level, contracts are at a different level. State enterprise also should be treated like any other contract. And I think the contracts must be run full course, and the treaties must be interpreted with the full force, as I agree again. But this plain reading versus contextual reading, is an age-old debate in interpretation of treaties. McDougall, the whole thesis of McDougall used to be that contextuality of treaty interpretation, and then there are others who want to go by the Leo Gross and others used to. This was 50s, 60s, 40s debate continuing even today. But when you sit there as a judge, you are not referring to any of these fellows. You are not persuaded by any ideological arguments on doctrinal matters. As a judge, your first duty is to look to the facts, and within the set of facts, applicable law, and if you take like simple mathematical application of the law, you do the facts, you normally get it right without having to really worry about all these unnecessary doctrines and violent things, which are good for the law journal articles and good for law firms to ensure that, all the lawyers, when I joined the law school, first thing the teacher told us in the first class was, now you all have come and joined this law college, and there's a great law college, and you know what you should know. When you become a lawyer, your client will come on the first day, and what is it you are expected to tell him? He will tell you all kinds of things, and some of it is irrelevant, and most of it is unusual, and most of it is against him himself, and at the same time he will ask you for advice, and he say, please twist my case. Then you cannot tell him, wow, because you didn't like to find the case is very interesting, and he will think that, so you have to keep the client, and you have to capture the client and his money. So how do you do that? He said, the only thing you have to say is, you be just, ibi remedium. If there is a case, you will win it. If it is right, you will get it. If it is justice, you will get it. So he couldn't understand. He said, oh my God, the lawyer got the point right away. You be just, ibi remedium. He said, oh my goodness, I think I'm going to be in a good lawyer's hands. Similarly, all these cases are you be just, ibi remediums, and judges will decide it according to their own and see the fact. If they're good judges, most of them are good judges. I think I won't have to good. I have seen all these fellows are very professional fellows, but to the extent they can find a fact here and lose a fact, they put the points, of course. But some of these having said the other point already, so I won't go into delay it. I won't delay you from lunch. I think this is a very, very excellent event. I must also tell you, I sat in a number of seminars throughout my life, both as a student, as a negotiator, as a law commission member. This is one of the best I attended. Thank you very much.
There as well. So what we can do now is quickly ask the panelists if they have any comments, clarifications, questions, either to each other or in addition to what they've already said, and then we can throw it open to the floor.
Down any obligations.
The umbrella clause extends to protections or obligations that have been undertaken before the treaty came into force or before the treaty was signed. I think it would be always read as a continuing guarantee.
So both before and afterwards.
Yes. And I think in many treaties they usually use the expression quite specifically. They say, and I think I don't have some of the BITs here, but there's specific language which says that it extends protections both to investments that were made before and after the BIT came into force. So that's the way that many of these BITs are routinely constructed.
One more on reference to this international custom. That also is at the time of BIT, or that maybe international custom that maybe prevalent at the time of the dispute?
Always at the time of the dispute. In fact, that's what generates the dispute. When there's a breach of international law, then that's the basis for a treaty claim. So, for example, if there's fair and equitable treatment, now the way the fair and equitable treatment standard is interpreted today is that, for example, if there's arbitrary conduct by the state, if there's a failure to protect a legitimate expectation, or if there's a denial of justice, then that breaches the FET standard. But 50 years down the line, if the fair and equitable treatment standard is much broader and there's a breach of the standard, then the way it would be interpreted is, how does it breach customary international law at that point in time, not customary international law as was frozen at the date that the treaty entered into force.
It's constantly evolving.
Basically for Vikas, you'd spoken earlier about how merely because of the umbrella clause you can't divest the jurisdiction of the domestic fora as well. I agree with that. Now, why I'm asking this is because recently, especially Professor Von Loh wrote an article about a couple of months back on fragmentation, and he himself says that this is an area that he does not know, where he speaks about if there are two tribunals with concurrent jurisdictions, the fact that each of the tribunals have concurrent jurisdictions is admitted. Now, in that case, would umbrella clauses lead to further development of fragmentation, in the sense that if the BIT tribunal, as well as the domestic fora, whatever it may be, the court or another arbitration in the local fora, how are they to deal with a simultaneous dispute in another fora? Now, what Professor Von Loh says is there are two ways to look at this. The way the first tribunal, the tribunal that gets the case first, must necessarily be different from the way the second tribunal looks at it. Now, my first question is, will the presence of these umbrella clauses and the wide interpretation given to them give rise to more of these fact situations where fragmentation will be caused? And second, if that is the case, then you agree with Professor Lau's argument, or what is the way forward for this?
What I think is the correct way. I think there will definitely be more fragmentation, quite simply because, unlike in the case of, say, an arbitration versus a domestic code, where a jurisdiction is mutually exclusive of the other, if you interpret an umbrella clause widely, say such as the STS versus Philippines case, you automatically vest two distinct tribunals with jurisdiction to deal with the same dispute. I use that as an argument to say that the investment tribunal should take into account this fact and therefore decline to exercise its jurisdiction. But if the tribunal goes ahead and does undertake the jurisdiction and decides the issue, then there will definitely be a case of duplication of proceedings. And that is something which is an inevitable consequence of a broader interpretation. Unless, as is done in the SUS versus Philippines case, one tribunal stays its proceedings pending the other being determined. But even then, it doesn't address the underlying issue that there are two distinct tribunals which have jurisdiction to deal with the same case. So ultimately, if the STS versus Philippines tribunal took on the matter once the arbitral tribunal finished it, what is the impact of the investment tribunal's opinion on what the arbitral tribunal decided in the domestic forum? It's an unclear question. I think that's the reason why we need to kind of demarcate territories, so to say.
On parallel arbitrations, which is, I think, is a topic that's covered in most textbooks on principles of investment arbitration. And there is a reference to a case which I don't immediately recall, where indeed there have been parallel arbitrations, and it is debate as to whether principles of res judicata and lis pendens would apply, and the difficulties in practical situations. For instance, one where, let's say, the holding company is the initiator, and another parallel arbitration under a separate PIT where a subsidiary could be the initiator of the arbitration, and therefore in the traditional context, res judicata and lis pendens would not have identity of parties, but they may be identity of cause of action to a large extent. So I think there is a fair amount of literature on this topic. It may be described differently in fragmentation or parallel arbitrations. I think Pramod had something to say. I had a comment after that.
And there are no easy answers to it. And there are no easy answers to it simply because one thing which Professor James Croft is very fond of mentioning is that there is no system of international investment treaty arbitration. If you have a system, that means that there's a very clear hierarchy, there's a clear delimitation of jurisdiction between different authorities, there's a proper appellate system which can actually harmonize the whole system together. International investment treaty arbitration is an ad hoc mechanism. It's not a complete, self-contained system, and that's the reason. And in fragmentation, the case that Shreyas probably referred to was a case involving the Czech Republic. Now, there were two entities which brought two different claims on virtually the same cause of action. There was a company called CME, which had its television license annulled. That made a claim against the Czech Republic Ronald Lauder was a national of a foreign state, a US national, and he made a claim against the Czech Republic under BIT. So there was identical cause of action, and there were two separate proceedings. And in one case, where actually Professor Brownlee was on the tribunal, true to his socialist roots, that case got rejected. But in another case, which had a more investor-friendly tribunal, the tribunal awarded damages of around $350 million. So a really, really substantial award on exactly the same cause of action. So you have parallel proceedings. That's an inevitable part of international litigation, and that happens. Now, that's with respect to the same subject matter and international investment treaty arbitration. But fragmentation as regards an investment treaty arbitration versus a contract arbitration, which was really a question, that again seems to be inescapable. And the reason is one of the reasons which Vikas mentioned. In a contract arbitration, you have a level playing field. And the reason I say that is because you can have a claim made by an investor against a state, but you can also have a situation where the state makes a counterclaim against the investor. Now, in a case which is the subject matter of today's moot court problem, you could also say that the state has a right to make a counterclaim. For example, because the national games were, let's assume that the national games were actually delayed because of the failure of an entity to provide these goods. Now, that causes national embarrassment, that causes loss, that causes damages. Now, shouldn't the state be entitled to recover for that loss? Therefore, shouldn't the state be entitled to make a counterclaim? Would that happen in a BIT arbitration? The answer is no, because you can only have a BIT arbitration for a breach of the treaty. But if you have a breach of the contract and where you have a state which has rights, then it has to enforce its rights in a contractual arbitration. So I would say that at one level, fragmentation is inevitable. I would say at another level, fragmentation is desirable.
If I may just ask it to be part of a discussion headed by Professor Vaughan Law on the very same topic at Oxford. Professor Vaughan Law, the discussion was a bit wider. It was not specifically to do with investment arbitration, it was international arbitration in general, though investment arbitration fitted in. So Professor Vaughan Law's view generally is that wherever possible, the tribunals must try and club the arbitration so there is just one proceeding. But obviously in this situation it is not possible because the fora are going to be different. In that context, two issues came up. If both the tribunals are equally competent to deal with the issue, the point that I had mentioned during my discussion, the later proceeding we stayed is the ideal way to go. But if, as Vikas mentioned, one tribunal is far more competent, for instance, if it's a construction arbitration and one of the tribunal consists of experts in the field, then arguments of forum non-convenience will come in, and it can be argued before the investment treaty tribunal that the more specialized forum is the better equipped forum to deal with the issue. In that kind of a situation, it is arguable that the international tribunal states proceedings rather than the domestic tribunal.
Colleagues to have already explained more in depth the point about fragmentation. Fragmentation, of course, is an issue that has been raised only in, not always a very sustainable arguments have been made against fragmentation. And because fragmentation at the international level, when Law of the Sea Tribunal was created, when the International Criminal Court was being created, when ICJ is already there is a big debate whether fragmentation is going to take place. But the question is, each convention, particularly some of these, whereas ICJ came under the UN and became a general tribunal for international law, the international in general, world court as it were, the other tribunals were created for specific purpose under a specific treaty, and there is a specific law has to be developed under those treaties, which also has to meet with the requirements of general international law to some extent. So therefore some fragmentation was inevitable when a different law and a more specific law was involved, as opposed to issues that come before the International Court of Justice. And so that was justified, as rightly said by Pramod once again, that some fragmentation is desirable thanks to the nature of the subject matter. But then the fragmentation as an issue is raised, whether it's arbitration, particularly in the case of very specialized situations which Shreya and others have mentioned, is that you need to, investors need to have, or states also need to have, or any one of us who are dealing with this would need to have certain predictability, certain certainty, certain continuity in thinking that if X, Y, Z, what comes up, A, B, C will follow. And if simply because I is sitting there and I'm looking for certain type of angles, not only for my personal promotion, but also I have a peculiar ideology of life. It doesn't take it with anybody else. Wherever I sit, I try to plow that field, and wherever he sits, he plows that field. And that kind of fragmentation is undesirable. I mean, that's where we need to really respect certain flow of logic in the, and how do you overcome that, even without any bad intention. This can happen because you come from India, that fellow come from, Vanlo is now, Vanlo is, I think, if he has not lost some hair, he would lose very soon. He is getting into too many arbitrations, and poor fellow has to fret from one place to the other, and he has to argue the same thing twice. Like you people are arguing the moot court in one case is arguing for one case, in another case is arguing against another. So he does not know how to match the two, so he feels about the fragmentation problem, I think. It's some of the same people running into the system is also a problem here up to a point. But more importantly, if ad hoc arbitration by nature is distinguishable from, because the type of people you constitute are quite different over a period of time in the entire world. So some inevitable perspectives will change and also differ. So therefore, it's the arbitrators, the nature of ad hocism, but then those who are participating must have a responsibility and certain self-discipline in ensuring that the most logically developed principles of law to the provide certain certainty and continuity and expectations of predictability. I think we have a duty to perform, and unless the judges perform their duty, this problem will continue to happen. Thank you.
A point that Mr. Rao just made again, I think I'm audible without a mic. The problem of people and ideologies is actually ever present, and not just in the biases of arbitrators. In fact, I was at a recent discussion when the same point was being discussed of counsel who act as counsel in one case and arbitrator in the next. And they sometimes have advanced arguments as counsel, and as tomorrow as arbitrator they have to perhaps take an independent call on an argument they have made the previous month or the previous week. And this is increasingly occurring statistically so. And there is, everybody, if I can take an unrelated analogy, everybody thought with the internet there'd be infinite players, more participation. In fact, we've seen consolidation like never before of power in very few corporations. And I think similarly on the international investment arbitration side, although we see an explosion of investment arbitrations, there is a converse statistical development happening of funneling of talent. And I have, out of personal analogy, anecdote can say that I've been the hand at the back of arbitration conferences, which has never got an opportunity into by stroke series of accidents into clubs called, for instance, the International Arbitration Club. And these are very, very small gatherings, and with people who seem to know each other. And it is one part of the investment arbitration world which is not law, but it is people related, but it's something that one cannot ignore in any responsible debate on the topic. That's the only point I want to make.
All forms of legal practice. So, yeah, right. If we have no more questions, then I suppose we can have a few more questions.
I agree with you when there are two, say, international fora, that's fine. But like I think Akhila ma'am said earlier, with a view to read down umbrella clauses, some people are saying this. If one of the fora is domestic and the other is international, normally the BIT will be signed earlier, subsequently a contract will be signed. Now in that case, through some slightly modified version of the lex posterior rule, will not always the domestic fora have jurisdiction. This is something that has come about in a couple of very recent articles. Which is why I'm asking, I'm guessing the reason behind this is because they don't want to elevate or deem those claims to go to the investment tribunal. So would that argument hold any good?
Firstly, there is no direct conflict because as all of us mentioned during our talks, the two are, a call of action for both are completely different. So one arises out of the contract, one arises out of the treaty. So there is no question of direct conflict between the two. The second point I would like to make is that in the context of investment arbitration, it is well established that the principle of exhaustion of local remedies is not recognized. So I am not sure if there are quite a few decisions which have held that way. So in that context, I am not sure whether in all situations you must say that the international proceedings must be stayed.
I was also wondering, so there seems to be some kind of a specialized law is developing in this more recent years rather than before, thanks to the ICSID and other things. I think ICSID is the real piece of the villain to my mind. The more I hear it, the more I see that white industry case. I skimmed through the pages. I didn't read it because of the lack of time and traveling, and the judgment was shown to me. I saw a number of these ICSID citations being given as if they are fundas from the beginning, I mean, these are all individually created law, and particular situations were different, and Latin American situations are mostly tailored there, and their context, social, political and economic context is totally different from other countries' context, and I think they are trying to elevate those principles to generalize them as customary international without any real basis in terms of acceptance and in terms of any understanding of what they meant. Therefore, from a contract to a treaty between two states as providing certain general assurances to where specific obligations are in the contract, and the contract has provided a forum and an applicable law, to jump to the treaty without having to go through all the necessary measures, which means exhaustion of local remedies, exhaustion of remedies as provided by the forum, if not local, you see, because sometimes the forum can be somewhere else and whatever. So exhaustion of remedies as provided the contract, if that has not been fully followed through, I think there should be a good case and a strong case against bringing PIT into the picture. Thank you.
So I have two questions. Like, one is just, it's a really small question to everybody, and one for Aditya. For everybody, actually, the question is, given that this whole question of the contractual agreements coming under the ambit of BITs came up, as in it's come up, and there have been BITs which have come in subsequently, isn't the fact that they haven't excluded contractual obligations in subsequent BITs something which points to the fact that contractual obligations are meant to be read under the umbrella clause? I mean, alternatively, it could be argued the other way as well. So, I mean, that's something which I just like to put out there for everybody. The other question for Aditya is, you mentioned under attribution, you mentioned the ILC articles, but under what articles of the ILC articles would you actually attribute things maybe for a state-owned entity? I mean, I don't think you can really bring it under Article 4, which is the organs of a state, and I'm not sure if Article 8 really covers it either, which is your effective control test. So how would you bring it, how would you actually argue attribution in that case?
So let's not compare
I'm handling it, but the question which I was sort of raising is the applicability of the ILC articles. Now, for example, in Noble Ventures, I'm not sure, I think it was, I'm not sure which article it was, but the application was on 528 with respect to a state-owned entity, whereas in Eureko, it was the Minister for Treasury. The only question that I was sort of raising is that, what is the scope of, is there any scope to actually apply the ILC articles, or has there been a sort of arbitrary application? Because like I said, the application has to, as per the articles itself, only arises on the breach of an international obligation. And the point I made right at the outset is that it's crucial to determine the sort of consent that the investor made with or the contracting party made with the state-owned entity. Was it aware at that point of this sort of level of attribution? Was it aware that the entity would be, is state-owned or would be subject to the same BID? And unless, and the only reason I stated that is that earlier there was a position where you can't just have attribution for any breach, it has to be a breach of an international law. Now it's been a breach of an international obligation, so the question is whether this obligation includes a breach of a contractual claim. So I'm not, as in I didn't particularly address whether any particular article applies, or it depends on the facts, I guess. But the broader question is whether the ILC articles should at all be looked into, and if they are looked into, what is the rationale which is applied, and that needs to be answered by the tribunals instead of just random application which seems to be happening right now.
So if you can address the first prong and then...
Position now as to whether contractual claims are or are not admissible with the there are conflicting opinions. So I don't think subsequent BITs going from now can be read in light of a intention that already exists, a state of law that already exists. So I think even for the near future, until the position is absolutely settled, it will be uncertain, even for future PITs.
Some people have traveled from afar, some people have sacrificed Sundays. So big round for our panelists. Yeah. And so I believe the moon court finals are scheduled soon. So I think the organizers have to get that ready, up and running in a while.
I am Nlsiam. These are my co-counsels, Preeti Korea and Vidya Mohanty. We are representing the respondents in the present matter, that is the Democratic Republic of Korea. We will be dealing with our objections to jurisdiction in the first instance, and I seek permission to quickly enumerate what our objections were to work on.
Yes, please. People are claiming to be respondent.
We are the respondent in the present matter, arbitrator, sir. We will be challenging the jurisdiction in the first sitting, and after that, we will respond to. I thank you, Honorable Tribunal. We essentially have two challenges to the jurisdiction of this tribunal. One is a concrete jurisdictional challenge. The next issue will challenge the standing of the claimants to represent the claims they have in the present case. Honorable Tribunal, the challenge to the jurisdiction will operate at two limbs. Firstly, that the jurisdiction rationale materia of this tribunal does not extend to contract-based claims, and secondly, that the negotiation clause in the contract between the respondent and the claimant will impede the jurisdiction of this present tribunal. If the tribunal is satisfied, I seek to move directly to the first argument.
Yes.
I thank you, Honorable Tribunal. Arbitrator sirs, we will be arguing that the jurisdiction rationale materia of this tribunal does not extend to contract-based claims at two levels. Firstly, we will demonstrate that Article 13 of the BIT does not subsume within itself contract-based claims, and secondly, that Article 10 cannot be read to elevate contract-based claims to treaty-based claims. Our first argument, Honorable Tribunal, as regards Article 13 of the BIT, will be first that the scope of Article 13 as in our present BIT is too narrow to include contract-based claims, and secondly, that as per an objective test, contract-based claims are not included. If I may direct your attention to the text of Article 13 in the BIT, Honorable Tribunal, Article 13 states, any dispute in connection with this agreement shall be resolved by arbitration. If I may invite your attention to page 3 of the written submissions, we have submitted, Honorable Tribunal, that as was decided in the case of SGS versus Pakistan, such a phraseology, that is, any dispute with regard to this agreement would restrict the jurisdiction of the tribunal to issues that arise out of treaty-based claims. Honorable Tribunal, we'd like to distinguish the case of SGS versus Philippines in this regard, in which the dispute settlement clause used the phraseology, disputes with respect to investments. Our submission, arbitrator sirs, is that this is a general term which can be contrasted to the specific term in our current BIT, which says dispute with regard to this agreement. And therefore, as was also upheld in the El Paso Energy International Company versus Argentina Republic case, on footnote 15 of page 3 of our written submissions, it is our submission that as per an ordinary meaning of this particular clause, it does not encompass contract-based claims.
Is that your only objection to jurisdiction, counsel? Isn't there a more fundamental jurisdictional objection that you can mount?
Certainly, arbitrator, sir, and I will move to the next objection.
No, can I just invite you? You mentioned Article 13. Now, is Article 13 triggered at all? Because the way it's possible to read it is providing only for dispute resolution between the parties to the treaty. And the parties to the treaty are not the parties before us. It doesn't seem to confer a right to commence an arbitration on an investor, because that's something that needs to be specifically provided, and that doesn't seem to have been the case here. So do we actually even have jurisdiction to consider the contract versus treaty claim issue, or does Article 13 just not apply at all to this dispute because an investor does not have standing?
Arbitrator, sir, our submission in this regard is that though in an ordinary circumstance one would envision that the doctrine of diplomatic protection would need to be invoked when two state parties enter into a treaty that does not specifically refer to private investors. However, the respondents in this case do recognize that the BIT paradigm changes this drastically and recognizes that the whole point of the BIT paradigm is to introduce a direct link between investors and the state. And hence we are not challenging the jurisdiction of this court on that ground, of this tribunal on that ground, pardon me. And instead we move to more substantial challenges to this jurisdiction, which is an interpretation of the scope of jurisdiction of this tribunal as per the text of the treaty. If arbitrators are satisfied, I seek to carry on with my submissions as regards jurisdiction.
So generous concession, counsel.
Certainly, arbitrators sir, would a generous respondent. If I may attract your attention to page 4 of the written submissions, our next submission in this regard is that Article 10 of the BIT cannot elevate breaches of contractual obligation into breaches of the BIT. If I may invite your attention to the text of Article 10, Article 10 states, each contracting party shall observe the obligations it has assumed with regard to specific investments by investors of the other contracting parties. And therefore, Honorable Tribunal, we identify two aspects to this particular clause. Firstly, there should be the existence of a specific investment and then an obligation that is assumed with regard to that specific investment. And therefore, our first submission in this regard, Honorable Tribunal, is that a purely commercial contract cannot be an investment under this treaty. If I may invite your attention to the decision of Global Trading Resources versus Ukraine. Honorable Tribunal, in paragraph 55 of this case, they summarize the primary issue in this regard when they say, the issue is the supplier's outlay of money in performing a contract for the transboundary purchase and sale of goods capable of constituting an investment? And the tribunal unequivocally stated that neither contracts of this kind nor the monies expended by the supplier in financing its part in their performance can by any reasonable process of interpretation be construed to be investments under a BIT. This was also held in the case of Joy Mining, where the tribunal recognized that these two issues are to be kept separate and distinct for the sake of a stable legal order. It is also a submission that the definition of investment in the bilateral investment treaty, if I may invite your attention to the definition on page 13 of the problem file, it defines an investment as every asset of a party that bears certain characteristics. Our initial submission in this regard is that an asset was defined in the Alastair Ross Anderson versus Costa Rica Tribunal, which defined an asset as a valuable item that is owned. It is our first submission that a contract cannot come under this preliminary definition. However, even in this regard, it is our submission that if the general practice the general treaty practice is taken into consideration, the only sort of contracts that could be included as an investment are contracts that fulfill certain characteristics that were laid down in the Salini test. Honorable Tribunal, these characteristics include...
In what context was the Salini test formulated, counsel? Wasn't that purely in the context of the exit convention and consent under Article 25?
Certainly.
So how is that relevant to an ad hoc arbitration, as is the case here?
Honorable Tribunal and arbitrator, sir, our submission in this regard, it is that it is not just the Salini test, but numerous tribunals, including FedEx versus Venezuela, RFCC versus Morocco, Alcoa Minerals, and the MSH award. And these, in keeping in mind these decisions, Schroer, in his commentary on the exit convention, also recognized that for a contract to constitute an investment, it has to be a contract that is in exercise of the sovereign power of the state. And this contract would have certain characteristics. For example, it would be of a particular duration that is of a considerable period. It would involve regularity of profit and return, a substantial commitment to the development of the state, a substantial assumption of risk. And therefore, our submission in this regard is further backed by the examples given in the definition of investment in clause C in the BIT. Our submission is that the examples given or enumerated in clause C include licenses, authorizations, permits and similar rights which could arise in a contractual framework. However, all these enumerations refer to contracts or a contractual relationship that involves the exercise of sovereign power of the state in the grant of licenses, authorizations, permits, etc. And that also contain...
Not private contracts.
Certainly, arbitrator, sir. Purely commercial contracts are clearly excluded from the definition of investment. And this makes absolute sense, arbitrator, sirs, because to hold otherwise would be to bring within the ambit of the BIT paradigm and an arbitral tribunal's jurisdiction each and every commercial contract that involves a state agency.
Can I ask one question?
Certainly, arbitrator, sir.
When you say sovereign function, the state in its own name should sign the contract to come under the BIT directly rather than in a contractual term. Is that what you are saying?
Not at all, arbitrator, sir. What I'm saying is that the contract should essentially involve not a purely commercial transaction, but a transaction that would involve the state participating as a sovereign state. And I'll give you an example. For example, the state granting a license for a particular activity, or as was held in the SGS versus Philippines case. In that particular case, it was a contract that involved a checking of the customs duty of the state. So these are all contracts that are not purely commercial in nature, and hence could be interpreted to be an investment. Our submission in this regard, as is clearly held by tribunals in global trading resources and in joy mining, is that a purely commercial contract of sale of goods cannot be included and under the definition of investment. And this is also included in the spirit of the definition in the treaty because...
just passing point of view, I'll just put it across and then let's see how you respond.
Certainly.
After all, this is the global peace games.
Certainly.
And this is a sovereign nation which is participating in it. So how more sovereign can you get, can the character of the state be when it enters into a contract of this kind?
Arbitrator, sir, this is the sale of goods, and I'll give you the joy mining case as an example. That case involved bank guarantees and a contract for supply of equipment with regard to a major mining project. And in that case, however, they recognized that the contract was that for supply of certain goods. And hence it was a purely commercial contract, and it had nothing to do with the sovereign power of a state, which would be the case in that of a license or a permit.
Well, you can't supply to the games unless the state approves. From what one can make out, the state is the ultimate regulator, perhaps even the owner of the games. In which case, everything that is connected with it is also owned by the state. The state obviously is negotiating for these largesse. The contract is in the kind of the largesse.
Arbitrator, sir, our submission in this regard is that a state can function either as a sovereign or it can even function as a merchant, and it depends on the contractual relationship. The contractual relationship will determine in what capacity the state is exercising its power. And in this particular instance, the state is only exercising its capacity as a merchant, where it is entering into a purely sale of goods transaction with a private company for supply of certain goods in connection with some project. And therefore, it is our submission that the ultimate purpose of those goods is not connected with the purely commercial nature of the transaction, and hence it remains a purely commercial contract.
So when it enters into a contract for supply of, let's say, defense trucks, although it is exercising a sovereign function, it is entering into a contract for supply of a commercial, it's a commercial contract. Is that what you say? I mean, if the facts were so to be transposed.
Arbitrator, sir, while other considerations of public welfare could make the issue more complicated in a contract involving sale of defense goods. However, if it was a purely commercial contract that involves the sale of a particular, the purchase and sale of goods, our submission in this regard is that this can be divorced from the ultimate use of those goods, and this is a purely commercial contract. If the Honorable Tribunal is satisfied, I seek to carry on with the rest of the submissions. Honorable Tribunal, our next submission is that obligation cannot subsume within itself contractual obligations. Honorable Tribunal, if I may divert your attention to page 4 of our written submissions, it is our submission in this regard that, as was recognized in the AMCO versus Indonesia case, there needs to be a distinction between rights and obligations that are applicable to persons as a matter of general law and those applicable to an investor as a consequence of an investment agreement. And our submission in this regard, as was recognized in the Pakistan case, in the SGS versus Pakistan case, that it is only when there is a clear and convincing evidence of a shared intent of the contracting parties to include contractual obligations that such obligations can be subsumed within the particular clause. It is also submitted in this regard that the wording of Article 10 says each contracting party shall observe the obligations it has assumed, which can be contrasted with the phraseology in SGS versus Philippines, which says each contracting party shall observe any obligations. And our submission in this regard, as was also said in SGS versus Pakistan, is that the use of guarantee the obligation simply does not, to our mind, necessarily signal the creation and acceptance of a new international law obligation on the part of the contracting party, where there clearly was none before.
Counsel, obligations can flow from different sources.
Certainly.
You can have an obligation that flows from the treaty. You can have an obligation that flows from customary international law. And you can have an obligation that flows under the contract.
Certainly.
Now, there's no need for Article 10 to say that a contracting party shall observe obligations imposed on it under the treaty, because that is understood. There is no need for the treaty to say that obligations under customary international law should also be given effect, because that is also provided in Article 5. Now, therefore, if we have to read Article 10 as having any meaning, it must necessarily refer to any obligations that flow from a contract, because that is the only source of law that is not otherwise dealt with in the treaty. If you read it in any other way, then Article 10 would possibly be rendered redundant.
Arbitrator, sir, however, our submission in this regard is that to read obligation to include any and every possible obligation would be to render superfluous each and every other article in the treaty. I'll give you an example, Arbitrator, sir. For example, the state has an obligation under the national treatment principle to ensure that two parties in a like situation, one a foreign investment and one a local investment, is not treated differently. Now, if this particular phraseology were to include every sort of obligation, then it would mean that this particular clause that says you have an obligation for national treatment principle would be completely redundant. And hence the submission in this regard is that the redundancy that would be a result of the current interpretation is nothing compared to the redundancy that would be the result of an interpretation that says that every single obligation would be subsumed within the phraseology. However, as a pacta sunt servanda clause, it ensures that the states meet their obligations, and we also submit that there may be other obligations, for example, tortious obligations, etc., that could also be included within this particular word obligation. If the honorable
why should we give it a plain meaning rather than go to some other body of law? For some of these may be exit arbitral awards, and why go there when the source of law is the treaty itself? It says it has assumed with regard to specific investments, with regard to each specific investment, and whatever be the investment. If a contract is an investment, that being subject to this, it has assumed with regard to specific investment by investors, and it's a mutually negotiated treaty. So why should we not read it literally rather than in a very narrow manner as you were suggesting?
Honorable Tribunal, my submission in this regard is that the repercussions of a broad reading of this particular clause would be so great, as was recognized in SGS versus Pakistan, that it would practically lead to the breakdown of a national-international legal order distinction. And therefore, it is only in the presence of an extremely clear and convincing intention of the two parties that such a reading could be looked into. And our submission is that other BITs have specifically mentioned that contractual obligations would be included in the umbrella clause. But this BIT does not even use the word any obligation, but says the obligations it has assumed. And as regards specific investments, it is our submission that the only reference it makes is that in each factual situation that different investment will be recognized. And it does not refer to the fact that it's an investment relationship. And our final submission is that Article 10 should be read harmoniously with Article 13. And if Article 13 states that any dispute in connection with this agreement, it necessarily restricts Article 10's interpretation to that of treaty-based claims. And hence, it is our submission that contract-based claims are not included within the jurisdiction material of this particular tribunal. If the Honourable Tribunal will permit me, I would like to take 5 minutes of the Tribunal's time to quickly explain the demonstration. As a quick submission, Honourable Tribunal, if I may attract your attention to page 5 of the written submissions, it is our submission in this regard that the negotiation clause between the two parties acts as an impediment to the jurisdiction of this tribunal. If I may invite your attention to page 6, footnote 32, we have mentioned the Enron versus Argentina case, when it was specifically recognized that a negotiation clause would be a jurisdictional requirement. Moreover, this has also been held in municipal law. In the US, in the New United Corp versus Excess County case, and among the common law jurisdictions in Hyundai Engineering and Construction versus Vigor, which is a Hong Kong case, in a UK case, Leicester versus Coates, and in the BIT paradigm, in Wintershall case, where it says that the use of the word shall imposes an obligation and not a mere option. Our submission is also that those cases...
Just before you warm up on this, I just have a threshold question. Is it your case that this interim measure of freezing of assets is open to negotiation?
Certainly.
Because it will implicate on the merits of the argument also.
Our submission in this regard on arbitrator, sir, is that it is the contract-based claims jurisdiction that is limited by the negotiation clause. We do recognize that the substantive treaty violations are not subsumed within this negotiation clause, and that will not, the jurisdiction of this tribunal is not impeded by this clause with that regard. If the Honourable Tribunal is satisfied...
Just interrupt and take you to page 20.
Certainly.
Now, this is the clause which provides for this multi-tiered dispute resolution. Can you look at the title of it, and can you see who the parties to this agreement are?
Certainly. Agreement between Wayne Electronics and the Ministry of Sports Government.
And can you also now look at Annexure 1, which is at page 13?
Certainly.
And see who the parties to this are?
The Democratic Republic of Colonna and the Kingdom.
So what you want us to do is to interpret a treaty between two sovereign states in the light of an agreement which is entered into by a ministry of a state and a private party. Has that ever been done in the history of International Arbitration Council?
Arbitrator, sir, our submission in this regard is that since the claimants seek to include purely contract-based claims within the jurisdiction of that can be invoked through the BIT, then necessarily those limitations that come along with those contract-based claims, which are included in the contract entered into between claimant and respondent, would also be attracted to impede the jurisdiction of this particular court. And hence we cite the negotiation clause to impede the jurisdiction. If I may please have 2 minutes of the Honourable Tribunal's time to quickly summarize the last issue. I thank you.
Again, to take this the same question further, I may be a little confused. Is there a separate contractual arbitration? I don't see one.
Because applicable law is the one that is governed,
yes,
rather than the arbitration with separate clauses.
Is there? Yes.
Absolutely.
Honourable Tribunal, there are two material issues or substantive issues before this Honourable Tribunal. One is based on the breach of contractual obligations, and one is based on substantive treaty protections. Now, what claimant seeks to do is take these contractual obligations and include them within the substantive treaty obligations. Now, we have objected to this, as has been argued by myself just now. However, what we're saying is that if you're going to take the substantive contract-based issues and try and include it within the BIT paradigm, within that jurisdiction, then you have to take along the issues that come with that specific contract. And if this contract stipulates that negotiation is mandatory before any other alternate dispute resolution mechanism is adhered to, then certainly that would be a necessity and would impede the jurisdiction of any tribunal that would hear a claim under this contract. Honorable Tribunal, if I may attract your attention to page 7 of our written submissions. We just a quick submission in this regard. We recognize, Honorable Tribunal, that the assets that have been seized are that of Wayne Corona, which is a company incorporated in the respondent state in itself. And therefore, our submission is that Wayne Enterprises does not have the standing to invoke the BIT to protect the assets of Wayne Corona. This stems from a very basic recognized principle of municipal and international law, which is that a company exists as a separate entity from that of its shareholders. Honorable Tribunal, a shareholder has no rights in rem over the assets of the company. If I may invite your attention to footnote 45, numerous cases have also held this. And therefore, a submission in this regard is that as it is only the interests of the shareholder but not their legal rights that have been interfered with when the assets of the company in which they have shareholding have been seized, they have no locus standi to introduce a claim on behalf of the company in front of this Honorable Tribunal.
Except in the case of an expropriation.
Honorable Tribunal, our submission in this regard would be that if expropriation is of the legal interest involved in shareholding, if my rights as a shareholder over the ownership of that particular share is interfered with, then I would have the standing to invoke this particular claim. But as we will demonstrate in the merits arguments, that is not true in this particular case. And even if the Honorable Tribunal were to consider the reflective loss test, which is a municipal test, our submission is that this test firstly cannot be invoked unless a company has been deprived of all remedies, and secondly, unless assets have been rendered completely worthless, and therefore this test even does not apply. If the Honorable Tribunal is satisfied in this regard, I'd like to hand over the platform to the